Imagine a future where the water you drink tastes of arsenic, the air is polluted, and the very court tasked with safeguarding your rights stood by as it happened. Who would you trust to seek justice? We recently witnessed the U.S. Supreme Court's ruling in Loper Bright Enterprises versus Raimondo, which marks a significant shift in administrative law by ending the 40-year precedent of Chevron Defence. In a 6-3 decision along party lines, the court overturned the Chevron doctrine, which allowed federal agencies to interrupt ambiguous laws within their expertise. What does this mean? Now, instead of deferring to agency expertise, federal judges will interpret certain laws that were once deemed technical themselves, significantly expanding their role in policymaking despite not being directly accountable to the public. This change reduces the power of agencies to enforce and implement laws effectively. For instance, before the U.S. Supreme Court ruling, if Congress passes a law to prevent corporations from polluting drinking water, the Environmental Protection Agency, EPA, would traditionally decide what constitutes a pollutant. The Chevron doctrine provided agencies like the EPA the freedom to create detailed rules without constant legal challenges, relying on their technical knowledge and expertise. Courts only intervened if an agency's interpretation was deemed unreasonable. This precedent has shaped numerous regulations on agriculture, water, climate, air quality, and more. The Supreme Court's decision has profound implications, affecting not only the rule of law, but also the functioning of agencies that protect the public from pollution, contaminated food, workplace hazards, and rising drug prices. This ruling represents a major change in how administrative laws are interpreted and enforced in the United States. In 1984, the U.S. Supreme Court established the Chevron Deference in a landmark case, Chevron USA, Inc. versus Natural Resources Defense Council, Inc. This decision arose from a dispute over the interpretation of a key term in the Clean Air Act, which Congress had amended in 1977 to require major stationary sources of air pollution to undergo a rigorous approval process managed by the Environmental Protection Agency, EPA. The Clean Air Act aimed to improve air quality by regulating sources of pollution. Initially, the EPA interpreted the term source very broadly to include nearly any significant addition or change at a factory or plant, such as individual buildings or machines like smokestacks or boilers. This expansive interpretation meant that numerous modifications would trigger stringent regulatory oversight. However, industries challenged this broad definition, arguing that it placed an undue burden on them. The case eventually made its way to the Supreme Court, which had to decide whether the EPA's interpretation of source was permissible under the Clean Air Act. Justice John Paul Stevens, writing for a unanimous court, ruled that the ambiguous meaning of the term source in the Clean Air Act indicated that Congress had implicitly delegated to the EPA the authority to make a policy decision about its definition. The court established a 2-step process for judicial review of agency interpretations of statutes. The first step was to determine whether Congress's intent on the specific issue was clear. If Congress's intent is clear, that interpretation must be followed. However, if the statute is ambiguous, then the second step is to determine whether the agency's interpretation is reasonable. If the interpretation is reasonable, courts must defer to the agency's expertise. Under Chevron deference, the EPA was given the authority to interpret what constituted a source of pollution. This meant that the EPA, with its scientific and technical expertise, could develop regulations and guidelines to implement the Clean Air Act effectively. However, in July 2024, the Supreme Court overturned the 40-year-old Chevron decision that had long shaped American regulation across many industries, including those impacting the environment. Loper Bright Enterprises versus Raimondo involved the owners of a New England fishing company challenging a regulation by the National Marine Fisheries Service. According to the Magnuson-Stevens Act, fishing boats must have government-appointed inspectors on board to ensure compliance with catch limits designed to prevent overfishing. These fishing companies bear the cost of these monitors, which for Loper Bright was about $700 a day. Loper Bright argued that the NMFS had no authority to impose this cost. However, a district court applying Chevron Deference sided with the NMFS, and a federal appeals court upheld this decision. The plaintiffs then took their case to the Supreme Court, which agreed to hear it in May 2023. The Supreme Court, in a decision that overturned Chevron Deference, ruled on the NMFS regulation. The fishing companies argue that Chevron gave too much authority to the executive branch. In writing for the majority, Chief Justice John Roberts stated that Chevron defies the command of the Administrative Procedure Act, which governs federal administrative agencies. He argued that the 1984 decision was misguided because courts, not federal agencies, should resolve legal ambiguities. This ruling represents a significant shift in the balance of power between federal agencies and the judiciary, emphasizing that courts should interpret laws, not agencies. The Supreme Court's opinion could make it easier for opponents of federal regulations to challenge them in court, potentially leading to a surge in new litigation and creating uncertainty for businesses and industries. Lisa Heinzerling, an administrative law expert at Georgetown University, emphasized the broad impact of this decision. If Americans are worried about their drinking water, their health, their retirement account, discrimination on the job, if they fly on a plane, drive a car, if they go outside and breathe the air, all of these day-to-day activities are run through a massive universe of federal agency regulations, and this decision now means that more of those regulations could be struck down by the courts. The Supreme Court's decision effectively grants itself and lower court judges a policy-making role that the Constitution did not intend for them to have. Instead of federal agencies like the U.S. Environmental Protection Agency and the U.S. Food and Drug Administration interpreting and enforcing laws to protect public health, safety, and the environment, these responsibilities will now fall to federal judges. This ruling could also spell trouble for California's ambitious vehicle emissions rules, which have relied on interpretations of the Clean Air Act from the Obama and Biden administrations, a law last amended in 1990 that doesn't explicitly mention greenhouse gases. With at least 9 of California's clean air rules awaiting EPA approval, the Supreme Court decision raises the stakes for the numerous court battles over the state's zero-emission vehicle mandates and other emission standards. Environmentalists fear that the end of the Chevron doctrine could lead to the elimination of hundreds of EPA rules designed to limit air and water pollution, protect people from toxic chemicals, and tackle climate change. The Biden administration had previously issued the most ambitious rules in U.S. history to cut climate warming pollution from cars, trucks, power plants, and oil and gas wells. Without these rules, President Biden's goal of reducing greenhouse gas emissions by half by the end of the decade would likely be unattainable, which analysts agree is necessary to avoid the most catastrophic impacts of global warming. The Supreme Court ruling may also affect the Clean Water Act, which regulates pollution in bodies of water. Julia Stein, Deputy Director for the Emmett Institute on Climate Change and the Environment at UCLA School of Law, noted, "While the courts are entitled to hear what the agency thinks, they don't have to respect it. They're open to adopt their own interpretation." This potential for federal courts to alter environmental rules highlights the importance of states having their own regulations. Stein emphasized California's robust state-level regulatory framework. "We have our own statutory scheme in California applied very robustly by state agencies here at home. So even if something were to happen at the federal level, we have a very robust backup at the state level to manage that." While there will still be a continuous fight to ensure the environment is safe and livable, states like California will need to leverage their own authority to legislate and regulate. However, the lack of strong federal support means states alone will not make as much progress as they would with a robust federal partner, leading to significant consequences for the climate in California and beyond.